So if you haven't already, make sure you click on resubmit in the daily participation text box will open up and type in the three most significant things. So civil rights and liberties. Civil rights are positive protections that the government has to make sure that we are treated equally. So civil rights include laws against discrimination, but in a way, they're also an interpretation of the Bill of Rights because, for instance, it says the Congress shall not establish a religion, means that all religions should be reflected equally, not one should be favored directly by the government. And so some of these civil rights are also enshrined in the Constitution itself, just like freedom of expression. It says we have a right to speech, and that also implies, of course, the government will not discriminate against people just because they have certain opinions that aren't popular with everyone else. And so that type of equality is guaranteed. Civil liberties are protections against government acts. For instance, going back to freedom of religion in the First Amendment, it says the government can't prohibit the free exercise of religion. So it can't stop you from practicing your religion within reason, of course. You can't sacrifice, for instance, another human being. That would be violating the law and committing murder. But as long as you're not taking away somebody else's rights, you can practice your faith however you want. And so the government can't stop you from doing that. The government can't stop you from owning firearms. The government can't stop you from having privacy in your own home. They have to have a warrant to intrude, for instance. So civil liberties are protections against government actions. And those, of course, are all listed in the Bill of Rights as well, for the most part. Now, for a long time, though, we did allow the government to infringe upon these both by curtailing civil rights and also by allowing them to have more leeway than they probably should have, which also meant there were less civil liberties. And for a long time, that was also considered to be the case, especially in extreme events like wars, for instance. The whole way up through and including World War I, the government often imposed restrictions on the First Amendment. The government also would, during wartime especially, go beyond its restrictions in the Bill of Rights and arrest people for sedition, going against the government and criticizing it. So it, in the past, gave itself a lot of leeway, especially the state governments. State governments in particular were allowed to bridge across the divide for civil rights and civil liberties and take more state power. However, the 14th Amendment, which was passed after the Civil War, said that the United States nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And so that basically set up the stage, and it applied to the states as well, that the Bill of Rights should be enforced, both civil rights and civil liberties. Now, of course, we know that was ignored because many southern states and some northern cities used Jim Crow laws and segregation for a long period of time. But by the 20th century, the Supreme Court started to affirm that the 14th Amendment meant that the Bill of Rights also applied to the states. And so starting in the 20th century, right around the time of World War I, they started to strike down a lot of laws in the past that gave the states more power, especially when it came to overruling our freedom of expression, or it gave the states more power to infringe upon our rights, violating civil liberties. And so this also meant that it opened the door for better enforcement of civil rights and equality in the United States. And that, of course, probably one of the most significant trials that went to the Supreme Court would be in the 50s, Brown versus Board of Education, which involves segregation in our school system. And that kind of set the tone for the next 20 to 30 years in eliminating discrimination, especially within the legal system. It had been de jure, which is spelled D-E space J-U-R-E, it had been the law that discrimination was allowed as long as it was separate yet equal. But in the Brown versus Board case, it was proved that the facilities are never equal. And even if they were, obviously because one group of people was segregated from the other, psychologically it's viewed as not being equal. So that is why segregation was struck down and Plessy versus Ferguson was overruled. And that, of course, was within government facilities like public schools. It wouldn't be until the 1960s, though, 1964, that the Civil Rights Act was passed. And basically, the Congress, through its power over commerce, interstate commerce, they said that businesses, especially those that were open to the public, restaurants, movie theaters, things like that, also could not discriminate. Now, that was, of course, controversial because that's a very broad interpretation of the power of Congress. And it is possible, of course, for a business, a small business, to not be affiliated with interstate commerce in some way. I mean, even a small town grocer probably got some of their items from another state. And so it's difficult to find a small business that doesn't have anything to do with anything else outside their state, but it is possible. And so those kind of businesses can sometimes fall through the cracks when it comes to civil rights legislation. And then other aspects of the Bill of Rights in the 20th century, especially the latter half, will also opened up. Rights of the accused were expanded. So now that we have to have an attorney represent us and we have to be read our rights, for instance, we can't be forced to confess to a crime. So that expands civil liberties as well, stopping the government from intruding and forcing us to basically confess to a crime and harangue us and harass us without any type of representation. So civil rights and civil liberties have been expanded dramatically in the 20th century. And going forward, both of these will be important because obviously as social media becomes more prevalent and digital files in particular, there is access to our private and confidential information. So right to privacy and how it's equally applied to everyone will become a more and more important thing as time goes by. Does anybody have any questions about any of that? Don't forget to submit your 3 points.